Impending issues for Missouri medical marijuana. Today's topic is landlord-tenant law. Can your landlord tell you no medical marijuana use in your rental? Can your landlord tell you that you cannot grow your own plants even if you get a cultivation license? Can you tell your landlord to pound sand if he does? Will your landlord having a federally backed loan on the property really bar your medical marijuana use? Medical marijuana is now legal in the state of Missouri. There isn't any available at this time, but if you're planning to sign a lease, have signed a lease, and are planning to get your medical marijuana card, then here is some important information for you to be aware of. My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law. Landlords may want to foster a 420 friendly community or kick budding herbalist healers to the curb. What are your rights, either as a tenant or a landlord? Leases are contracts. Contracts are very important. First, we look at what does the lease say, what do the statutes say, and what does the Constitution say? Article 16 of the Missouri Constitution now enshrines your right to medical marijuana. 2018's Amendment 2 is now Article 16. It contains a lot of protections for medical marijuana users, but also exposes some risk. Paragraph 5, subsection 1 states that the possession of marijuana in quantities less than the limits of this section shall not subject the possessor to arrest, criminal or civil liability, or sanctions under Missouri law. The proposed rules for qualified patients allow the barring of marijuana use by contract. Landlords, and I've heard from a few, may not want a medical card holder smoking marijuana or growing marijuana in their house. Really, it comes down to this. When a landlord thinks about home cultivation, he pictures a massive grow room with LEDs, hydroponics, moist air, heavy with a pungent aroma of growing cannabis. It's a smell that just cannot be easily removed. When the medical marijuana user pictures their 6 flowering plants or 12 total plants, they picture a cute little herbal planter on a set of shelves with LED grow lights and the sweet smell of a pain-free night. So will your landlord be able to kick you out for smoking or growing weed? Yes. Without protections, a landlord could object to your using a room to cultivate your personal use plants. This is a contractual issue. Do not avoid the subject. Tell the landlord that you intend to grow your own medicine as soon as you can. Get a clause in your lease to protect yourself, or an addendum such as the ones that we're going to be offering. For the landlords, if you're going to ban marijuana usage and cultivation on your property, you need to be adding those terms to your leases now. If there is not a clause in the lease or a marijuana addendum, then you may have issues stopping the tenant from either using marijuana or cultivating marijuana at your residence, or you may have issues stopping you from stopping them from doing that. As for the argument that marijuana use or cultivation is not allowed because the landlord has a federally backed home loan, I have yet to see a clause in the mortgage documents that requires a landlord to prevent a state licensed activity. That doesn't mean it isn't in there. Mortgage loan documents are massive contracts, but I can't put my finger on one clause at this moment. Now, we have prepared a package of Missouri lease addendums for medical marijuana. These are forms that can be used by a tenant or the landlord to either expressly allow for medical marijuana use or denial of use, cultivation or denial of cultivation. The package is available as a download on pattalkslaw.com. That's pattalkslaw.com. And it is reasonably priced at $25. Hit the like and subscribe buttons. Hit the alert button for notice of our next video. Thank you.